we give a scientific comments for the national legislation, so the individual persons can address to our institute for having the scientific comments or conclusions. How can it be helpful in the cases of trial proceedings? Some work can be interpreted in different ways, and in order to justify your side, they address to us for concluding scientific justification. As for the problems of resolving traditional issues, first of all, as we all know, every client has demands quick resolution of their disputes, and quickly we can't manage it to do it quickly. But the main pain for all lawyers of intellectual property practices is the competency of the judges and understanding of judges the cases itself about the problem of the particular case. Sometimes it can be so that the judges have the character. Some courts ratify their judges. For one judge for several years can lead only cases on the intellectual properties, and then he goes to. And then they transfer for the civil cases, and the patent lawyers tend to talk about the nuances of their practices. And as being the counsel of the minister, I tried to manage this question, but I needed the support of the society, and I will talk about this later. So the competency of the judges is the problem number one. We have some difficulties of transborder disputes. For example, we have some trademarks that are registered that have international registration, but for different classes, they are not presented in Kazakhstan. And there is a question of coincidence. For example, I had such case with the trademark Motorola. It was registered. It has international registration and it has one certain classes in Kazakhstan, but there are another people who wanted to have such trademark, and this is a common practice that we need to give the documents in English, and there are some cases when the judges don't know English, and in these cases we need to attract translators, interpreters, or to translate it from the court itself. And in general, there are some cases when we have a restriction of confidential information in the trials. Very rarely, but we have some such moments. So when I was a counsel of minister, we comprehended that in Kazakhstan it is impossible to have the courts of intellectual properties. Why? Everyone knows the reason, because in Kazakhstan the circle of disputes on the market is not such in a wide range as in the countries where the intellectual property is one of the biggest institutes of the judicial trials. So we have picked such a way to propose to courts to have a circle of colleagues, of judges that could work only on the questions of intellectual property. So there was, in order to not have to exclude a great number of judges from the circle of this colleague, and to relate it to the other colleague and what was the reaction of the judges. So there was a difficulty in the point that in the government this is another authority and the judges is another uh, part of our governmental authorities. So what was their reaction? They didn't have any reaction. So we continue. Okay. In 2022, in the civil processual codes, there was another article novella, and this is another way to resolve our problems. What can it be helpful for us? For example, in Almaty, there are two sides, and the subject of the dispute is in Almaty, but by their mutual agreement, they can refer the disputes to other agencies or courts because there is a certain uh, judges that work in this field, but the main problem that I need that we need to explain to judges the main barrier is that judges we can't explain to judges that the market of intellectual property is a dynamic one and it's constructed on the some precedents in cases. We need to recognize that the market of intellectual properties includes the trials that are on some certain precedents. In 2014, in the USA, there was a precedent of the World LC versus Valerie. It was a null case, and after the case, it was to the circle of the judges working for the intellectual property. They started to include pictures, and with the technological advantages, it can be very helpful to have such practice, and we need to concentrate on this topic when some trademarks can transfer and another trademarks. And for example, if he worked in a different sphere, and it's very difficult to explain it. Thank you. So currently, I presume that a great mechanism of resolving this problem would be a creation of arbitral courts with the support of Kazpatent and with the support of International Financial Center of Astana, and it will minimize the time that is devoted to these cases, and also we could have a free choice of specialized arbiters in this sphere. We could pick some professionals that we don't have to explain about the dynamical range of the sphere. One of the opportunities, the ability to have applicable law. For example, in France, there is another arbitrary court for the patent cases. In Portugal, is the compulsory arbitration on the pharmaceutical patents. And in the U.S., there are some restrictions of effects of solutions into parties. For example, if there are some trials between two sides, the resolution of this is not affecting the registration of the trademarks. So the potential of Kazakhstan for attracting foreign people on their arbitral courts is a very big one, and we need to. There is an urgent need of the support from the governmental side and having some amendments. So, talking about the questions, we will talk about it later when every speaker will share their practice in a very wide range, and we'll answer your questions, and then we should continue. Thank you, Alia Madiyarova. Director of Patent Attorney of the Republic of Kazakhstan, about the trademarks disputes. Please, Alia.
Всем здравствуйте. Рад.
Good morning, everyone. I'm happy to greet to all the listeners and colleagues who are persistent in online and offline formats. Before they proceed to the presentation, I would like to clarify who I am, the company Vitozovich Group. We try our best to advertise ourselves. We need to be informed about who we are. Before, we covered only CIS country and Europe and Eastern Europe, and not so far ago, back in 2023, which joined with two major companies specialized in intellectual property, and now we cover you can sit over here to see the screen. And Petoshevich merged with two major companies, including CNB, and now we have a name of CWB, and we cover the regions highlighted with red color on this map, covering 4 regions, 29 officers, and more than 150 practitioners in the fields of IP. The topic is objection to the registration of trademark applications, a key stage of pretrial defense. We insist on the pretrial resolvement of the dispute because on the stage of registration of the online applications, we identify the parts of the online objects which violates the rights of the right holders, and that is a kind of a unique opportunity when you really can stop at this point and resolve the issue. And the objections are quite important because at this particular stage, the right holders, in most cases, are part of sending the application to the patent agencies. Additionally, do participate within the pre-trial resolution with the violators. Plus, this stage really simplifies the work of the further system, reducing its workload, including the appellation processes and further judicial resolution. And we need to understand that all the system, if it would be framed in the effective way, it is much more better to have more pre-trial resolution in order to reduce the number of judicial cases. So here we describe the grounds for objections, deadlines for filings, fees, the bodies and characteristics, and further we will discuss this table in details. Here you can find out information on 7 countries. Not in all countries we do have an opportunity to publish the applications of the third parties. So in Azerbaijan, as we know, the paid agencies do not publish the applications, and the third parties have no opportunities to identify the indicators which violates the rights. What's for the ideal option to verify the perfect procedure for application? Yes, we do, and I will touch upon this later on. Almost in all countries, the grounds for objections are absolute, or we call them other, relative, for send an application objection. But only in Armenia, they send an objection on the basis of relative grounds when the right holders have some concerns of registration or the object of intellectual property. Further are deadline for filing an objection. Before this, I would like to say that not in all countries we do have such a procedure. In most cases, objections are sent in the form of informal letters on alarming or notification in certain countries. When they are sent, we pay no fees. And the only hope here for the right owner or representative of the right owner that this letter would be seen or within the attention of the expert. There is no guarantee of this letter to be the substantial evidence or affect the situation substantially. So in 2022, it's been implemented an opportunity to send an objection, and since then we face some challenges within the work of the system. First of all, as you see from the slide, that is quite short time frame from identification in the register, which is still published monthly in annually in Kazakhstan and each month in some countries. So the duration is quite small, and not all of the objects are able to fill the form and then to send them and address to the representatives of the patent agencies in order to accept or assess the opportunity of sending the objection, or then to agree on further sending or not sending of the objection. For instance, in Kyrgyzstan, they do have such a procedure of objections, and they provide the 3 months. That is the biggest time frame within the region. In other countries, there is no such an opportunity which is legally confirmed with sending objections with a certain deadline. But in Russian Federation, to the third parties or any stakeholders to send an objection against registration of objects of intellectual property to the intellectual property agency in case of expertise on actual case. But in practice, objections are sent within first several months, and then it gives an opportunity for the expert to discuss this certain application. Let us also discuss the difference on the fees. Till the 2022 in Kazakhstan, we have practiced a method of sending of the letters of notification with no fees, and with indirect way we've been able to notify the expert or patent agency that the application, which is within the expertise, violates the rights of right owners, and then to provide an evidence and in most cases the information, all the grounds and the key moments should be depicted within one letter, and that is similar to the one bullet, which should be able by one shot to convince the expert that registration will violate the right of right owners which have registration within the country. I haven't reached the most interesting parts, and there have been questions on pretrial regulation of opposition. That would be interesting for the governmental bodies. And as you see, by paying 65 US dollars, we can send an objection, but and that is a kind of the warranty to be sure that this objection would be discussed by experts. In Armenia, $25 and in other countries with no fees. Then the decision is made by the group of experts, despite the fact have you sent or not the fee. The expert discusses the decision on the grounds we provided. And here I noted no difference, so we can send the letters with no fees, with no limitations, so within 1 month, for instance. And the decisions objected within the court in Armenia, in other cases in chambers, for instance. The peculiarities of procedures, not only in Kazakhstan but in other countries where we do have such a procedure, on results we notify the figure, the person who submitted the comment or objection. In Russia, for instance, the application materials are sent upon payment of the application fee, so we can request some decisions or notification, everything connected with the application. But in Kazakhstan, under the Article 11.2, any stakeholder can send an objection, and what's for the result? The stakeholder becomes the third party under the Article 11.11. And within the discussion of the application, no material provided to the third party. And they do not provide us any information on registration or lack of registration of the object. But when we pay the application fee and send an objection, we still receive no notification. What to do in this particular case? That is quite a huge issue, and if the application is registered, we can see it within the register, governmental register. But just imagine when you receive refusal, it could be objected again and again, and then we can spend months in the appellation court and so on. So it could be prolonged through the years, and we, being the side who sent an objections, we simply do not have any understanding of what is happening right now, and we can regulate it in a different form to send the letters and so on. So I do suggest to discuss the experience of other countries, and you have 1 minute only left for the speech. That is international experience on the procedure of objection within the European Union. They sent the claim. They send an application, then within 3 months they publish these applications. After the 3 months of public publishing, any interested party or right holders of the intellectual property or trademark owners, they have a right to send an objections by paying the fee with a total sum, if I'm not mistaken, 320 euro. Then the objection is considered by the experts. Then the procedures with the full description is sent to the interested parties, and in order to have opportunity to discuss the ways of settlements. And here I depict the calling off process, that is a kind of cooling period which lasts within 2 months. and within the agreements of the parties could be prolonged further to 2 months, and then within the voluntary settlement or in the other way, like the arrangements on coexistence, or one party can buy the trademark from other party, anyway to have a common grounds and to stop the opposition process at this stage. Anyway, the fee which been paid is paid back for the parties, and that is a great opportunity for the parties in general. And I think all the countries who have an opportunity to send the objection to use this practice. And if one party is against, we can continue the procedure, and only within this moment parties can provide the evidence or more extensive information, provide any data on particular objection. Thank you. That is the huge block of information, and we can discuss it further again and again. I would like to draw attention to the fact that the questions we will discuss after this section. So the last one, I already draw attention to the key issues, that is the differences in procedures and time frameworks in our regions and the opportunities. If I'm not mistaken, it's not the presentation I sent. The key problems been connected with the lack of time within the countries. In some countries, they have an opportunity to send an objections or not. In our region, we do have such an opportunity, but it's too complex with limitations, and I would like to notice that the key advantage of this procedure on simplifying the appellation councils and chambers and courts, as has been noticed, we can some objects of intellectual property, and not in all countries we do have the courts on the intellectual properties. And at this particular stage, it is quite essential, depending on the composition of the procedure and the implementation of it. And it is also essential to cover the moments of the parties, so it will lead to the fact that we will decrease the workload on the further bodies. So that is the great opportunity for the governmental body to pay attention to this practice and settle the disputes. In this way, probably you addressed this proposal. Yes, of course, we do have the National Intellectual Property body, and we share the proposals. Do you have any results of this? Yes, they do understand the importance of such practice, but not at the level we suggested. Probably we need to amend the process in some points, probably in terms of time frames and so on. And I noted the procedure, the opportunity of resolution on the conflicts on the pre-trial basis. So once again, we touch upon the interpersonal relationships and the pre-trial settlement, because anyway, we do cover this issue apart from the following one. The management company of the holding, the last holding, Andrei Chinkin, leading specialist in the intellectual property department.
What's known, dear colleagues, dear participants of the International Forum, I will try to briefly talk about my presentation, and I will proceed to the practice. practical part of my presentation. So the restricted right to use was founded in 1963 and Bilas in 1991, and 47 justifications in foreign countries, and in 2022, Rospatent justified this trademarks Bilas in the Russian Federation. The algorithm of justification of the trademarks, of violation of trademarks. So the worker of the Department of the Intellectual Right Partner, identification of the fact of the on the marketplaces or different internet platforms. The juridical person is the testing on the subject of realization of the licensed goods by the customer, and the screenshot on the screen, and it should be very clear and readable on the packaging. What is the problem here? There is no data about the realized goods of the dispute products, and in most cases the plaintiffs note that in their cases it was the single one, and the resolution of this problem can be in the quantity of the reviews of the consumers, and the statistic is not statistic about annual statistics of the identified violations on the November 2023, October 2024, on Wildberries 11, Zone 39, Mega Market 9, and other internet sources 7. What are the goods offered to the sellings with the violations is the toys or galleries, puzzles, or another goods. The detailed work on every aspect there is a violation with the written pretensy, with the justifications of their violations, and also they should pay the compensation for the monetary losses and exclusion of their goods. In total, there was 66 claims. The juridical person, including juridical person, of the number of 6, individual entrepreneurs 60. The satisfied claims of pretrial settlements, there was 7. The serious problem of detailed work is the complexity of identifying the juridical address of the individual entrepreneur. We can address it to the agency of the taxation department of the Russian Federation. The sum is not very big. They will give us the address of the juridical person. And we always do it in such way. About the 25 claims was issued in the arbitral courts of the Russian Federation. 5 juridical persons were related to these cases. Individual entrepreneurs 20, in the relation of legal entities 2, and in individual entrepreneurs 8 cases. They were satisfied fully or partially. The sum of the compensation was above 400,000 Russian rubles. What is important when having a claim, you need to maximally have arguments about the dimension of the material requirements to the plaintiff and to formalize non-material requirements. I will not talk about the specific examples. You can visit the official site of the Arbitral Court of the Russian Federation. my.arbiter.ru and see all the decisions of the courts. It was very different and interesting ones. And in conclusion, I want to say that Belarus is one of the global leaders of the production of career tracks, and it's always of a high quality, following the rights of the violators. First of all, you need to achieve the violation of an exclusion of such actions in the future. And the next goal is illegal installation or in the civil turnover of trademark brands. As a result, in 2024, 9 licensed contracts is concluded. Thank you, Andrei. We found out that Belarus doesn't have any problems with the trademark. Is there any problem? The problem, I have talked about this problem, and you have seen it. We were impressed that the great number of goods are being sold by another trademark. Thank you, Konush Tursunov. The floor is yours, the Director of International Patent Center, Patent Attorney of the Republic of Kazakhstan. The timeline and the main problem that you can tell us about within your activity.
I will try my best to be brief, and I depicted everything within 31 slides, so let me be brief. So the trademark is not only the logo, that is your representation of the business, and you need to understand that you have the certain image within the market. That is why within the framework of this presentation, I would like to explain how we create the trademark, how to have a pre-trial resolution of the conflicts. So with attaching of the work of lawyer specialists and the representative. So the exceptional cases arrangement on the trademarks. We do have a process of requiring the rights on the trademark. So briefly, I explained how we send the application, how it is assessed with the expert organization, the process of requirement of trademark. For those who will join us via YouTube translation, that could be very helpful. We do know that we know to liquidate the lack of knowledge and expertise in this field. So there are several stages. I will not cover all of them right now, but at least it's shown right now. I switch slides because I do want to touch upon everything. So the trademarks categories are divided into two groups: commercial and non-commercial. The commercial are the disputes between companies related to the use of trademarks in commercial activities, including rights of violation, fair competition, and conflict in cooperation. And non-commercial disputes connected with the process of requirements of trademark rights and further objections. If there is any objections from the applicant's side. Commercial disputes are the categories, once again, when we violate the exclusive right on the trademark, and that is probably one of the most form of the commercial disputes. At this stage, we witness the infringement of an exclusive trademark in conflicts within which we can identify the use of almost identical or confusingly similar to the trademark. The next one is unfair use, when in that particular case you receive only temporary right. and one of the most popular disputes also within the territory of Kazakhstan. And I think that is common issue for the old post-Soviet countries when there is the commercial disputes on unfair competition, because here we involve the participants of the market. So for the unfair competition, once again, we refer to the use of trademark or similar identification for the reputation of another brand. And so we also covered very interesting history on the TikTok. Who would will imagine that the TikTok has the category 43. So we follow step by step of investigation. So, and the next one is breach of contractual obligation. Sometimes the side which receives the rights violates some paragraphs of the agreements, and that is a type of the commercial dispute. And also international aspects. I will not cover it in details because it's been described by my colleagues. So the next one is non-commercial disputes. Only two buttons, but I still cannot distinguish them. So the non-commercial disputes, that is the process that the applicant or the representative representing the market wants to receive a right on trademark. So the expert organization, as I show depicted in the previous slides, makes a decision on verification of the trademark and its compliance with the necessary articles, like 36. And that is a category of administrative disputes, like a refusal of the registration of trademark. And decisions made by the Appeals Council of the Ministry of Justice of the Republic of Kazakhstan also could be involved. And there are some distinguishing characteristics of these procedures. And non-compliance with the trademark terms of use, there is some scientific part of this when we misunderstand the article, which covers that the trademark should be used in the form in which it's been registered. So if you change any form of trademark, you need to register this. That is right, I think. And with the conclusion, I would like to identify the key reasons or grounds for occurring of the disputes. I know that within the Kazakhstan, it occurs only the registration. The rights occurs only after the registration of the trademark, and that provides an opportunity to protect the rights owner. For the protection of your rights and decisions, it is essential to register trademarks timely, to be informed on the conditions of the agreements, use the judicial and non-judicial mechanisms. All the instruments are applicable for the different cases. The pre-trial settlement resolution, that is a kind of the attempt to put out a fire at an early stage before it breaks out and causes serious damage, because we are all people and people have disputes with other people. And here we need to understand that each person has an individual approach, and within the resolution of these disputes, we need to pay attention to the psychology, marketing principles, and suggest some condition on resolutions of such cases. I will not draw attention to the particular cases because it is hard to identify the separate one, because that is a long process of strategy, and it's a kind of the chess games. There is no particular scheme. That is why I would like to discuss stages of pre-trial settlements. The pre-trial settlements at this stage, it helps to resolve the issue before the judicial resolution. The one of the most important stages, negotiation, where we, as I mentioned, that is a kind of a chess game, and here we provide evidence in the form of in the form of affecting the person, despite the fact that there is other opportunities. So in a simple way, we try to describe that there is no need to pay a fee and go to the stage of the judicial resolution. So the non-commercial disputes with administrative governmental bodies, sometimes disputes arise not with the other market participants and the state bodies or enterprises are involved. Sometimes we can receive the second objection, then send the objection to the appellation council, and in all countries of the CIS, the procedure is the same. And within my website, therisinpress.com, it's express depicted, and you can get my contacts to get the further explanation. We have 41st article of the law that the whole register of the objects depicted within the 41st article in paragraph 2. As I mentioned, I have 31 pages, but probably it is better to identify the most problematic area and the ways of resolution, because we are all professionals and we do understand the algorithm procedures and stages and nuances. Your pain and your suggestion for resolution. My report is in most cases oriented for those who are online, not for those who are offline. So the dispute resolution, the experts do understand that in order to reach the results you want to have, we need to be prepared for this process and undergo some preparatory procedures. So like before the statement of the claim, we need to collect the evidence and to collect the documents which covers other governmental bodies or any relationship which are connected with the object of the dispute. That is for the commercial dispute. So the preparation of the statement of claim, filing the claim in court, consideration of the case in court, and making a court decision. So here we also communicate with the lawyers, experts, and representatives. So they try to help to resolve the conflict before the judicial resolution. Key decisions are made by the Appeal Council of the Minister of Justice of the Republic of Kazakhstan, and two conditions are under the jurisdiction of the Appeal Council of the Minister of Justice of the Republic of Kazakhstan and Astana City. The process of resolution of administrative disputes, it is a kind of a different one, but anyway, we send the administrative appeal claim, then discussed within the process. For the resolution, we have only two options, yes and no. So the courts can support and refuse. So the process of plaintiff. Here we touch upon the restoration of violated rights, recovery of compensation, strengthening the legal position. We can have a discussion with other subjects of the market who are potential violators. For the violators, the consequences are worse because that covers a commitment to stop the violation, financial implications, confiscation of products, and reputational risks. For this, we need to be educated in terms of particular registers. And here we have administrative responsibility and criminal liability. Administrative one is one of the tools of the pre-trial resolution, and for the criminal liability, that is a kind of last resort option. And I think that the publicity of of such cases is one of the important aspects for the society, because we form the certain legal culture and promote the respect of the subjects of the market to the law itself. And they start to understand the fiscal parts of this subject, and it positively affects the daily practice and court system, because sometimes judges cannot have complete understanding of the subject of the right. The role of lawyer and specialist on all the stages, because sometimes we have the specified lawyers, and in some cases we do have lawyers who have no specialization in a particular area, and sometimes lawyers attempt to depict their knowledge, but they are not connected with the tangible rights. Professional support of lawyers and intellectual property specialists is like a reliable compass in the rough sea of legal nuances. I will briefly touch upon each point. Performing a preliminary research, understanding the requirements. The first one is in the process of registration of trademark. So the formulation that I will do everything by my own is not the beneficial one, because we have a lot of nuances which you need to have a compliance with. And in this particular case, I can inform the visitors and listeners that within the portfolio we can suggest the most effective registration and so on. Pre-trial, I already touched upon. In the conclusion, I would like to draw attention to the fact that the brand itself plays an important role. That is the thing requiring the valuable, reliable legal protection, and from trademark registration to representation in court, we need to have a specific spectrum of proof, and it is very essential for the business development. We do have successful cases within the Kazakhstan on production of the groceries and drinks, and it has certain history, and here's the impact on the market. And I always announced that the more articles you can find at the services, so for the bridge between the consumers, I mentioned that there is a lack of understanding from the side of consumers. So the same issue, the problem of liquidation of lack of knowledge. So enlightenment is the thing we need to do. I think the arbitrary process is one of the most effective ways of resolution. I would like to draw attention to the fact that we can have mechanisms within the arbitrary courts which are already existing, because we have a law on arbitrary disputes, and the disputes connect with the governmental body in terms of non-commercial disputes. This could be sent in the category of the arbitrary processes, because considerations such as disputes could be or should be framed within all the legal bases, and the person who covers the resolution of this dispute should be qualified for that, with the great expertise within their decision-making. It provides the opportunity for the further scientific research and the further development of the new practice. And any decisions are made only after the initial stage of negotiation. And the most important suggestion is to create API, which we do have in Russia and other countries, in order to receive information from informational systems like CASPAT and Patent. That's all. Thank you for your attention. Thank you, Kionish. We are almost elaborated the regime of work, but within the last minutes, we would like to draw attention to the Karina Skomrokhova, senior lawyer of the practice combating counterfeit and gray imports, Semyonov and Pevsner LLC. We'll talk the black and gray market, counterfeiting goods.
As introduction, I want to thank for the opportunity on such events, and thank you a lot for thank you a lot. I thank Kazakhstan for the organization of such forum this year, and I will skip some slides. If you want to look on some certain slides, you can contact me, and I will send you the full version. So the first block of what I want to touch is the evolution of the judicial practice in the court context of the parallel impulse. In 2024, in Russia Federation, there was legalized some good products, and the import of such products was considered as non-violating rights on the trademarks, and it led to some dangers of the right holders that new regulations cannot be scrupulous companies for the import of the counterfeit products, and laying the responsibility on the new regulation. And how is it evaluated in the judicial practice when it was installed first? There was the violations was before the installation of such, and such provisions could be considered. And further, the practice went so that it was about the matching of a correspondence of certain products, and the courts also considered about the party selling this product. Was it corresponding? If it was corresponding to the criteria of such trademarks. And finally, the court pointed to the impossibility to the cases when it touches the counterfeit products, and we know that this practice is taking place, and we recommend the participants of this process and right holders and the representatives to be ready that the potential opponents will use the links in the new regulation to avoid such responsibility. And the next block is that I want to mention, I will do it very quickly, the questions of the calculation of compensation. And I will remind for someone that don't know the sphere of the Russian law agency. In Russia we have three criteria to violate: is to have compensations in the fixed amount and of a double value compensation, or the right to use the trademarks in the right way. If we calculate it, we see such tendency is having such compensation in a fixed amount. And my colleague is specialized in such cases, and we see a big dimension of such practice. And now it is very common practice that in some cases the court is limited by the minimal sizes, and in other cases the court doesn't minimize the amount of compensations and satisfies the demands of the right holders. And another one is the diminishing of the compensation funds. And the next one is the doctrine of the unity of intentions, and it was in the plenum dated back in 2019. So if the compensation for the one episode of violations can be set only in the cases when the counterfeit products were purchased in different times of one individual entrepreneur, is referred to one good party, and for several cases of the controlled purchasing is set out, and therefore only for one episode. And I want to note that in such case, courts have different reactions on such provisions, and we have such court practice that they react to the case that they defend the rights of not one certain person and for single performers. And we see that this practice is very comfortable and efficient. You can have a photo of this slide because I will not stop on this topic, and I will proceed to the next way of restoring the rights of the right holders of the double taxation. Here is the principles of having the right dimension of compensation. I will go to the next slide. Is the accountability of the real products. And what the courts are saying in this case, if the right holders wants to have compensation for the maximum quantity of goods that is meant to be the maximum amount in the bag, and it could lead to the minimizing the amount of compensation and leading into that amount that was really purchased. In my opinion, this practice is a strange one because there are some practices, some algorithms that can that provides opportunity to have a real number of goods that we want to add, and it can minimize the. And it's not clear for us if is it a good intention or not. And I think I want to believe that this tendency will change. And during over several years of this practice, the courts compare the violations based on the territory and the volume of the rights with the conditions that were in the licensed contracts that the right holder uses as the tool for his claim. And we will proceed to an interesting case is the compensation of the losses. This practice has been very very interesting during over the past years about the Dior and Chanel, about the trademarks of the individual entrepreneurs, and tried to go on the way of the line of the compensation losses. And the case was very. I'm sorry. It has a long. It took a long time and finished and crossing the stage of the original court. What was the case? The position of the Supreme Court was in the following way. The right holders couldn't justify that in this case they need to compensate the losses, and the contradiction product was the biggest one in the market, and the other sellers couldn't post their products on this marketplace, and the compensation and the losses were minimized. And I want to note here that going to the court for the compensation of losses was a rare case now, but nowadays it will be a very exotic example, and it will be applied only in the cases when there was an evident fake representation of the original trademark. I will show you 2 slides about the juridical force of the having the rights. Here is the practice. Here we have the practice with the difference with 2 or 3 months, and the first one it was not sufficient, and the another case it was sufficient evidences, and the right holder should look at this point. And a very new tendency of past few years of using on the judicial judicial trials is the existence of the marketplace. Such services like such software can sum up the information on these websites, and with the help of these marketplaces, the right holders justify the size of the compensation using the number of sold products. Somewhere it is recognized, somewhere it's not, and it is very pleasant for us that we see some resolutions that this service has a full right to be justified. And from concluding everything that I have said before, according to the new laws and the previous laws, the lack of the general standards in this field and unpredictability for the right holders and the increasing of the court fees, court duties, and it's not about an important factor or non-formal factor, but it is a very important factor and is very important in several situations if the right holders has some difficulties with the accumulation of the data. If he can't find out the information about the numbers sold of goods, and when they have an opportunity to have the supply chains, and he can have some discussions with the sellers and reduce the amount of compensation. They have more important data obtained, and the place where it came from is for the wholesale is a low. Another one is a low arbitral compensation that we can identify in some profiles. Thank you for your attention. Thank you, Karina. We once more highlight the role of courts that, despite all the principles of the authorities, has a very successful work in the legislation settlements. And we need to bear in mind, as the Institutional Court in the Russian Federation, that in 2018 successfully posted the publication that models a lot of information cases as in the counterfeit sphere is and become one of the principles of such positions. Thank you, Karina. And we will listen to another speaker, Silya Ibrahimova. No, we don't have this performer, and I congratulate you with the termination of our section, and the material is left in our chat, and we can use the WhatsApp as a platform for our further conversation, and you can exchange with the information you have with other participants. And one of the favorite topics of the registration of trademarks. Thank you a lot.
Раз. Слышно, да? Я в эфире уже.
Здравствуйте. Алло.
Еще пока не начинаем, у нас начало через 10 минут.
Да, я подключилась, чтобы просто удостовериться, что я смогу загрузить свою
Это Дилия, да?
презентацию.
Вот наши коллеги,
Да.
они переформатировали вашу презентацию в Microsoft, да? В другой формат, который можно будет показывать. А она сама сможет управлять онлайн? Потому что у нас там, получается, 3 спикера онлайн. Да, она онлайн. Ага. А у вас получится, Диля, поделиться вашей презентацией? Попробуйте сейчас.
Да, вот я как раз все это время сейчас пыталась.
Угу.
Так.
Говорят, что идет. Ну вот на экране не вижу.
Секунду.
Нет. F5 надо нажать или что?
Здравствуйте. Изначально нужно презентацию сделать full screen, а потом в Zoom выбрать при нажатии кнопки «Поделиться» широкий экран вашей презентации. Вот, ура, замечательно.
Вы все видите, да?
Да.
Окей.
Но мы еще вашу фотографию видим. Она перекрывает часть презентации. Спасибо.
А если я так, меня видно будет? Или как-то мне можно будет убрать себя в сторону?
У каждого участника Zoom в отдельном окне видно ваше лицо и вашу презентацию.
Окей. Так нормально, да? Потому что я не вижу сейчас ничего.
Так, на данный момент не видно ваше видео, картинки.
Какой именно картинки?
Веб-камеры вашей не вижу. То есть черный экран идет.
Не знаю, потому что у меня включено вроде все.
Можем проверить, пожалуйста? Спасибо.
Так.
Да, все, спасибо. Так. И вы на презентацию опять можете эту функцию отключить, чтобы посреди презентации появлялись вы? Или так надо?
Я не знаю. Нет, наверное, как-то по-другому лучше. Секунду.
Так, сейчас. Давайте посмотрю. Может, так и оставим. Да, вот сейчас хорошо у меня на половине экрана презентация ваша будет идти в трансляцию, на другой половине ваша картинка, видео. Все, спасибо.
Ладно, одна фотография, и мы начинаем. Добрый день.
Good afternoon, dear colleagues. Let's start our section. First of all, let me introduce myself. My name is Rotina Marina. I'm the Deputy Chairman of the Committee on the Rights of Intellectual Property of Ministry of Justice of Republic of Kazakhstan. The Ministry of Justice is one of the representative body on the questions of intellectual property rights that develops the core policy in the sphere. We are gathered here to discuss the role of a new region object of intellectual property and geographical position indicators. Such indicators are widely used around the world in the development of the agricultural products and some beverages or the goods that have a close connection with culture. I want to know that the amendment was changed in the 2022, but we have only 5 registered geographical indications. And so last year we have done a lot of work in this direction with the government, and about 100 of applications we have on the consideration. And you know the geographic indicator is an Almaty port, and as among the registered one is Kazlarda rice, Talgar pear, the Kokshetau ice cream, Kostanay honey, and others. And also I want to know that this work was started due to the fact that Kazakhstan started bilateral discussions with negotiations with the Committee of the Geographical Recognitions, and other countries are also interested in having such a work with the Republic of Kazakhstan, and also it's very relevant to have the work with the Republic of Kazakhstan on the joining the Lisbon Agreement. That also is considered about the geographical indicators in the framework of the WIPO. And on this moment, I want to give the floor to our distinguished speakers, and I want to thank all of you for participating in this forum, and also thank the viewers of our online session. And first of all, Dilia Chanusheva, thank you for connecting to us on such early time. Dilia is one of the young experts of the Lisbon Registry, Brands and Design Sectors, WIPO, but she also worked before in our agency in the Associate Patent of the Republic of Kazakhstan, and she will talk about the role of WIPO on the questions of the protection of the geographical indicators. The floor is yours, Dilia.
Good morning. Thank you, Marina, for the opportunity to report this topic. I'd like to also to say thank you for the opportunity to participate in this forum. My presentation would be in the English language, but I've been requested to report in our Russian language, so sorry for having slides in the English language. Please do not misunderstand me. First of all, I'd like to thank you all. Good morning, dear participants of the forum. My name is Dilia. As Marina already introduced me before, I am the young expert of the Lisbon Registry, brands and design sector of WIPO. And for me, it's a great honor to present a report on the topic of the role of the World Intellectual Property Organization in promoting international cooperation in the GI protection. Especially, I would like to report of the specific system and the participation of the countries in the region. Within this report, we will cover the key role of protection of geographical indicators, the role of International Organization of WIPO, and also describe the current situation of the project's Lisbon system role in protection of GI. But before, allow me to report more on what are the geographical indications. Due to the article number 1 of the Geneva Act, that is a sign used on products that have a specific geographical origin and possesses qualities or that origin. To function as a GI, sign must identify a product as originating in a given place. Such factors like climate, ground, or human factors like traditional methods of manufacturing. The location can have the plethora of geographical indications also registered into the official register of WIPO. And I would like to introduce several examples, like the olive oil from Toscana, famous due to its characteristics and the great quality of ground and traditional methods of manufacturing, Colombia coffee, to the specific methods of growing and also the Cameroonian one, which is famous for the ground and volcanic characteristics of origin. To following one that is for the groceries, a part of that due to the introduction of Geneva Acts, there is an opportunity to introduce geographical indications for the handmade crafts like the silk Long Provence, which contains a lot of traditional qualities. We will proceed to the question why we need to protect GIs and what an importance it has. For producers, the GIs helps to protect the geographical production on the market, saving its unique characteristics and quality that allows to sell the goods on the higher prices, preserve the traditional methods of manufacturing, and increase the profits for the regions. At the same time, it worth to note that the geographical indication can be transferred to the other regions. It also plays an important role for the consumers, providing the insurance that they buy the products with a particular origin and complying with the high standards of production of the goods that allow us to be ensured that the geographical GI production is registered and controlled. A part of this allows to impact to the agricultural developments involving the local producers for the local manufacturing processes that provides the standards of the quality and the quality of good within the market. It also improves the incomes in the rural area and also to suppress the migration processes from the rural areas to the big cities. It also positively affects the development of the regions and the countries as a whole. They do attract the tourists which are interested in the local production that stimulates the economy of the region. And a part of this, the production with GIAs improve the economical image and preserve the cultural heritage for the further generations. That is a relevant issue. So GI protection is beneficial for all, for the producers in the rural areas, for the consumers, and for the other countries and regions. It also provides us the cultural, economic, and intellectual heritage and cooperation in this regard. experience shows that the protection of GIs has a positive effect on different aspects of the industry and life as a whole. Let us discuss the key steps for the protection of GI. First of all, it's registration. The first step is the registration GI in the respective body. Formally, not in all countries we do have such the register, and sometimes the governmental bodies are provide the function of protection of GI. And after this, the protection itself, it's not the only mean, because after the completion of the registration, it is essential uh, to verify the key tendencies on the market in order to timely change the measures of protections. And they are distinguished in different countries. And a part of this, we need to have the specific book of specification and quality control, which guarantees the use of the GI goods. That is why the necessity of reading the specification is quite important. We need to also pay attention on the unique characteristics of a product due to its geographical origin. Let us discuss the role of WIPO in GI protection. WIPO provides a platform for discussions and completes key functions. First of all, it provides, as has been mentioned, the platform for discussion of GI protection through the Distinguished Committee on Preservance of GI goods and samples. A part of this, there is a geographical protection of GI, and we classified two international systems which could be connected with the GIs. First of all, Lisbon system, which I will describe in details further. It helps to implement international GI system. A part of this, WIPO registers Madrid system, which also interacts with GIs but through other means. And Madrid systems allows to register certificated signs and also captures GIs. However, I would like to emphasize that it's only used in those countries which are protected through this means, like in the United States, because they don't have a separate system devoted for the GIs, because they're protected within the collective and certificated signs. And WIPO provides the technical support and policy-making assistance, and also providing support of using GI as an instrument of tool of economical development. I would like to emphasize that we introduced a new approach based on the project activity. It emphasizes development of specific projects. We take them into consideration, discuss, and organize some activities in this perspective, and I will explain them in details in order to achieve real and valuable results. So it is beneficial to use this approach. That is why WIPO supports international systems, providing the necessary platform for discussion and tools for registration. Further, I would like to draw attention to the technical assistance provided by the WIPO, especially the Department of Lisbon Register. The WIPO approach is project-oriented, as has been mentioned, and at the current stage, we finished and implementing a wide range of projects all around. And WIPO provides the help to the local communities. So that refers to the associations which focus on the development of GIs. Commercializations, effective management also included, and it's done by the request of the governmental bodies or respective bodies. We do cooperate with UN and other non-governmental bodies. The examples of the projects of WIPO, which are terminated right now, and there are the different other stages. First, Vanuatu Kava, we consulted, we built, organized trainings within the 2024 in order to enhance the enlightenment in this perspective. Also, within 2023, we organized a regional workshop of training on the strategy and protection of GI at the national level. We provided the assistance on improving the legislative framework of Vanuatu on enhancing the protection of the reputation within the market. WIPO plays an important role for the Jordan products too. Also, there's been a cooperation with the National Center of IP in Georgia, provided assistance in various projects and within the organization of different events. One of the recent projects is Vanilla Cacao. We provided the help in terms of PDP projects and involving the local authorities and stakeholders, everyone interested in GIs. A part of this will probably help in elaboration of the legislative system, improvement of the current policy, and providing the protection of GI. I will not list all of the projects we have because we have a very long list of them. Most of them are terminated, and we have also the list of projects which we plan to launch in the nearest future. We have several phases to undergo in order to provide the assistance. First, we have structural and steady approach in assessment, that is phase 0, where we evaluate the current condition, and here we focus on the analysis of the specification and reputation of the product motivation of the producers, conduct market analysis, and review of the institutional frameworks for the further protection of the GI. On the phase 1, which is pre-registrational one, on GI protection, we developed the framework for the further protection of the GI. Here, we also touch upon the development of the book of specification for production standard. It's one of the key elements which formulates the standards of the manufacturing and provides the unique characteristics of the quality. The second point is establishment of the Producers Association and definition of the business models. Then we follow up with the phase 2 on the post-registration. Here, within this stage, we focus on the maximization of the advantages from the protection of the GI. That is development of the collective control system and also commercialization strategies, development within the branding and marketing, with the focus on the establishment of logos and packaging in order to make it visible, attract attention, and be successful in terms of commercialization. Apart of this, we provide the instruments for the protection of the GI in order to prevent the infringement of GI use. And this approach provides the maximum implementation of GI and provides the opportunity to protect all the traditions in terms of manufacturing the GI products and promotes further economical growth in the rural areas, as has been mentioned before. That is a future project. I would like to make a remark that that project is on the stage of negotiation, and we hope that we will launch it in the beginning of the next year, because now we at the process of introducing the amendments, and that is a project on protection, collective management, and commercialization of geographical indications in Central Asia, covering Kazakhstan, Tajikistan, Uzbekistan, and the plan till the next year, within the next year, with introduction of the Lisbon Register. To launch this project, probably my colleagues will introduce it in details further within these three products. The key target is to provide the legal institutional framework within these three countries, improve the collective management within the protection of Almaty port, white honey, asbashi, and also apricot. The key objectives of this project is for strengthening legal and institutional capacity of the GI protection, capacity building, and also establishing control of the cultural heritage of the region. Within this slide, we presented several projects already implemented and which are quite crucial, which provides the financial income within the market, and that compote pepper, which is originated in Cambodia. I will not introduce further details in terms of digits and samples, but I'd like to draw attention to the fact that compote pepper and jaba figs from Tunis and banana de Costa Rica are spread through the market in a great number, and so they attract a lot of attention, and the products are registered at the market as the trust for her products, and all the information on this projects is available on the WIPO website. You can get knowledge of the articles there. Allow me to proceed to the Lisbon system, which is which been adopted in 1968, which is 58, and it provides the protection of GI. It acts within the agreement of appellation of origin in 1958 with amendments in 1967. There are description of the tools within the WIPO, and it provides the opportunity to the producers to protect their namings and GIs within 44 contracting parties and up to 73 countries that provide us with the effective economic tool of the protection. And in 2022, Geneva Act was enforced, and that's provided for the development of the protection of GIs. It also covers the handmade products, including silk, for instance. This is the example of handmade products. After the classification, implementation, it's used in all the parties of the system. These are the kinds of the internal aspects, and it's enforced up to the fact of be reinforced, and also there is a need to reaffirm its system. If once you registered, there is no need to pay a fee in order to prolong the right use. Here you can see several projects with the examples of the GIs registered within the Lisbon registry. They demonstrate the variety of the production which is protected and connects within some geographical origin. You can see the diversity of the projects, including beverages, handmade things, groceries, vegetable and fruits. I would like to draw attention to what is the Geneva Act, which has been developed within the 2019 and been enforced from 2022. It's been included to the Lisbon Agreement, making it more accessible for the wide spectrum of products and legal systems, including the protection of the GIs, fulfillment to the namings, and that allowed to the wide range of the GIs namings to require the protection from the systems. One of the novelties is flexibility, allowing protection through sui generis systems, trademark law, or other legal frameworks. Referring to the sui generis systems, I would like to mention that here we refer to the specialized laws. Apart of this, we refer to trademark laws and other methods of legal frameworks depicts the diversity of the protection. Geneva Act enhanced the capture of the Lisbon system for the international organizations like EU and WIPO or OIP. Possibility to request individual fees and fee reductions, which allows to cut their expenditures on the implementation of GIs on the territory, like expertise and so on, based on the local body. At the same time, reduction of the fees, as I mentioned before, for the range of countries, making the system available, so making the discounts for the less developed countries. This provides the opportunity for the producers to provide the protections of the GIs on the international level. Here you can find the scheme of the Geneva Act work. The first stage is the title of protection, the implementation of the protection, and we provide the protection in the country. There is it's originated from after the sending the international application. A part of this international application could be sent directly to the WIPO or EU competent bodies or other bodies if it's allowed by the country of the origin. In most cases, it's sent throughout the bodies. So we provide expertise assessment and verification if the application complies with the key elements of the requirements we introduce it into the system. At the second stage, we provide the certificate of registration for the contracting parties of origin. At the first stage, we provide the experts substantive examination on the domestic law and provide the evidence for conducting this examination. The respective bodies could refuse the application or provide the protection. Here is the first stage described. For opportunity of having the protection or denial, or in terms of receiving no answer, we provide the autumn bite-size protection. System provides the protection due to the implementation of different practices within certain countries. The Lisbon system provides the high-level protection and protection from any counterfeiting use or falsification, like ST or something like. Lisbon system provides a timeless protection, which covers the country of origin with no fee, no additional fees. That also economically beneficial because that provides the wide spectrum protection for the unified form of application. Part of the system is beneficial for the producers, saving the reputation of the projects and providing the common register in the system, unified. One of the major risks is that the third parties can register the GIs as the trademark and have an opportunity to use it apart from the originated regions. Let's consider one particular example. Here you can find the famous camembert cheese, and probably it is possible to think up on camembert. Camembert, is it protected GI or not? Camembert is the soft cheese originated from the Normandy region. It's the north of France, and it's produced by the cow milk, and it's characterized with the white covering with, and it has the unique processes of creation, and originally it came from the France Normandy, which completely complies with the requirements for GI protection, but now it is used as the general naming for the cheeses produced in other regions, which excluded them from the GI protection register. It is still this particular type of cheese, Camembert de Normandy, is still protective within the GI register, but the Camembert itself is not, because it is used in other countries. Camembert de Normandy is the protected GI, but if the Camembert received the registration, it could be protected as a Camembert name itself. Indicators of the origin is Camembert Normandy receive the opportunity to be protected of the GI worldwide. Here you can find the brief information on the protection of within the European Union. Throughout the recent years, after the acceptance of the Geneva Acts and the enhancing of the membership of the European Union joined as the organization. It also introduced the system into force after the joining of the EU, and African Organization of Intellectual Property also joined and enlarged the persistence in the countries of the Geneva Act. currently, only up to the 4 years of being in force of the Geneva Act, we captured 64 countries. The last of them are Djibouti, Slovakia, Montenegro, and Moldova in July 2024. We do expect other countries to join the Geneva Acts, including the Africa continent, Latin America, and Uzbekistan, which is at the stage of discussion. Actually, do you have an opportunity to communicate with speakers? If you have an opportunity to ask a question, I can give a mic. I would like to hear from the audience if you do have a time, because it's restricted. Unfortunately, you exceeded the time framing because you prolonged the presentation. That's for the general brainstorming, despite the successful cases. For this question, I think each speaker will introduce the key advantages and challenges within the GIs in the region, and so within the summary of this session, they'll provide recommendations. That is why I would like to ask the speakers to think on this, and I will announce the recommendations which I made within your reports. We also announce them to the audience. Thank you. Despite the success of the protection of the GIs, there are still the cases lost at the international level. The judicial systems varies from jurisdiction to jurisdiction. Some markets cannot provide the same level of protection. So the level of protection is different within the countries. And that is why the producers tend to provide all the set of evidence for the further protection. It could be quite costly process, and simply we cannot resolve the issue in the effective way. A part of this, it is important to consider the key distinguishing factors and the levels of protections within markets. In the future, we are waiting for new implementations in this regard, including the sustainability and protection of environments. And a part of this, the global markets are interconnected. And so the Geneva Act and other international agreements will continue to play an important role in order to provide the commercialization and protection of GIs. The more detailed information on functionality of Lisbon system and specific GIs registered undergoing special stages and technical assistance you can find via this QR code on our official website. I would like to thank you for attention, and if you have any questions, you can address them to this email due to the lack of time. Thank you, Dila, for your reports. On your behalf, I'd like to thank WIPO for all the support provided by this organization. And the next word I would like to give to Malgorzata Silvinska-Kleiner. I hope she's online. I'd like to ask you to check the connection.
Good morning. I cannot switch on my camera for some reason. Maybe you can unblock it, or we just look at my presentation instead of on me. I think that's the most important.
Malgorzata, yes, we also have problems switching on your camera, but that's fine. We can see your presentation, I hope.
Okay, I will share it.
Хотелось бы вот представить Малгорзату, она является представителем...
I would like to introduce the speaker. She is the representative of the World Intellectual Property Organization Committee on Agricultural Commission of the European Union, having a great experience, and more than a year the Republic of Kazakhstan has negotiations with the European Union on concluding the agreements on mutual exchange of the red lists of the GIs, and based on this list, our producers will gather the access to the European markets, and their production would be considered as a production of high quality, which is generally production identified by the GI. Everything is good with the presentation. The floor is yours.
Thank you very much, Marina, and thank you very much for for inviting us to your conference. I will present you the experience in the EU in protection of geographical indications, and I will focus on the benefits for the producers, because I understand this was, you asked that this would be the red line, let's say, through my presentation. I will not repeat what are geographical indications, because I think everybody knows, and it was in the previous presentation. But I would like to insist on one thing, that the geographical indications is the key for the system, meaning that there must be a link between the geographical area and the product. The geographical indications are enshrined in the area they belong to, and therefore geographical indications, they don't belong to any producer, they belong to the region.
Малгорзата, секундочку. Я прошу прощения, у нас, оказывается, нет наушников в зале. Сейчас мы принесем наушники, да. Можно, пожалуйста, попросить коллег принести наушники? Сколько наушников нужно? Да? Нет, ну нам должны были. Угу. Малгорзата, прошу прощения за заминку.
Malgorzata, I'm sorry for the waiting. You can continue talking.
So for that reason, that geographical indications belong to the region, anybody that produces in the delimited region and complies with the specification has the right to use the GI name for its product. And this is the key element for us, and it's the basis for the system and for its function as a rural development instrument. I will speak about it in a moment. In the EU, we have 3,500 GIs, a bit more than that even. Some are world famous. Maybe you recognize some of them on the pictures, and they bring added value, but some are less famous. A protection doesn't bring automatic success, and I think it's very important to remember. It requires a constant work on the side of the producer to keep the quality, to market the product, to put promotion efforts. And it also requires engagement of public authorities. And I think it's important to keep in mind because oftentimes the producers think that it's sufficient to protect the name and the added value will come just because of the pure protection. It's not true. It still requires a lot of work. Here, I just want to insist, I don't see fully the slide. I want to insist on the two logos that you see on the side. One is for the protected denominations of origin. One is for protected geographical indications. The difference is that protected denomination of origin has stricter requirements. But I wanted to insist on the logo itself. It's a very important common marketing tool for the producers. I'm not sure if all the countries have the logo. We think it's a key element of the system because, in short, it certifies to the consumers that the product is a geographical indication. Just briefly, we have now one regulation protecting geographical indications for all the products. Before we had 3 regulations, and we certainly recommend to have a consolidated legislative framework and to have the protection for all products under one regulation. Applications, very briefly. Because this comes again to the fact that the geographical indication doesn't belong to any producer. In the beginning, it's the producers group that establishes the specifications, so the description of the product and the limitation of the geographical origin, as well as the producer group chooses which control body will check whether the producers comply with the specification. This is a very important aspect. I will also speak about it later. And once this is established, meaning the specification and the control body is chosen, this producer group sends the application to the competent authorities of the member state. Member state does the necessary procedure. If the decision is positive, the application is further sent to the European Commission. We repeat the procedure, meaning checking whether a GI is a GI. We also run an opposition procedure where all the interested stakeholders can oppose registration of a geographical indication. But once this geographical indication is registered and protected, it's not only this producer group that can use the GI, but anyone in the region that produces according to the specification that this producer group agreed with and submits itself to the checks of control body, anybody can use the geographical indication name on its product and the logo. So we don't have the list of authorized users. Maybe the control bodies have on their level, but in the Commission, for instance, we don't have a consolidated list of authorized users of all the GIs in the EU. And that's very important. Not very important not to have the list of authorized users, but the fact that anybody in the region can use the GI name, because it means it's a very accessible instrument. And therefore, we call it a rural intellectual property. Here I will not elaborate on controls. Controls is a very important element of the system. It is twofold. First, there are control bodies. It can be public authorities or private control bodies that are accredited. They are checking whether the producers comply with specification. And then when the product is on the market, public authorities, it's usually food safety bodies or a unit in the Ministry of Agriculture, it depends on the member state. They do regular checks on the market, so in the shops, online, to check whether there are any infringements of GI's rights. In other words, if there are any misuses or fake GIs, to put it blunt. And they work on the basis of the shortlist. So since you saw in the beginning, we have 3,500 GIs, it is impossible and not necessary to check all the GIs every day on the market. So basically, those authorities, they have a short list of GIs that are most prone for infringements on their market, and it varies from member states to member state, and they are checking on the regular basis. Also, it can be that anyone, even just a consumer that noticed an infringement in the shop, can notify public authorities that they noticed this occurrence, and public authorities have to act. And this is very important for producers, again, to come back to, let's say, the red line through my presentation, because small producers have this protection by public authorities for which they are not paying. Yes, it's the obligation of public authorities to protect the rights of geographical indications. Key elements, we are protecting the name, not the product. I'm saying this because oftentimes it's a misunderstanding. Anybody can protect a white cheese, but only the producers in the region of the limited region of feta can call it feta. Protection is unlimited in time, as opposed to trademarks. And I know that in some countries also the protection is limited for 10 years, for instance. In the EU, it is unlimited. The protection is against misuse, imitation, or evocation, and other practice that would be liable to mislead the consumer. Yeah, the rest I was speaking about, any operator, and controls and enforcement. Benefits of geographical indications for producers, as again, this is the main topic of the presentation. Protection of the name. As I was saying, there is administrative protection, so no need to go to the court in most cases. Obviously, if one wants to go to court and claim damages, this avenue is also open. But public authorities, they shall ensure purely that the product that is infringing GI's rights is not on the market. And it depends on the member states how they enforce. It can be with penalties. It doesn't have to, it's not necessary that there are penalties. What the objective is that the infringing product is not on the market. It's sometimes enough to simply change the label. And I will also say that central authorities or local authorities are not only involved at the stage of control of the market, but also in the first stage of the process. It also depends on member states, of course, yes, but it is very important to support the producers groups in setting up, in establishing the specification, or even earlier, to support the producers to create this producers group, to delimit the geographical area, and even to find the geographical indications in the region, because it's the local authorities that know their area, and they know the potential. Logo, which gives differentiation on the market. Again, important for small producers that oftentimes they don't have any marketing department, and otherwise they would not have access to any branding instrument. So they have a right to use a GI name. and they have right to use logo, and that is recognized by the consumers. And this logo, obviously, it brings the associations to the consumer that it's a product of quality, and it's important because a lot of efforts are put to promote the brand, to promote a GI. So if in addition you have a logo that reinforces this message of quality for the consumers, it's a very important element of the system. Added value, I have a graph later on the average added value for geographical indication in comparison to similar products on the market. But of course, this differentiation allows for getting a better price and a stronger position in the value chain. And again, as I was saying initially, of course, GI is just a tool. It can be successful or not. Yes, producers still need sales and promotion strategy. They need to define a strong brand, so have the usual graphics, logo, label, logo meaning of their own brand. They have to identify their market. They have to have story behind their product. Of course, GIs are, let's say, good storytellers. But in any case, again, it's important to put efforts in promotion of geographical indication and not just register it and wait that the benefits just come. Benefits for consumers, as per slide, it's basically what the message the GI logo sends, that the consumers will not necessarily know the specification. They may even not know exactly from which geographical area this product comes. But seeing the logo, they will link the product with high quality, with local production, with small producers, with tradition. So that's the trends. That's what the consumers in Europe are searching more and more. And are ready to pay a higher margin, which again comes to benefits to producers. And the benefits to the region. In the EU, as in many parts of the world, rural areas face the population. And in the EU, we have instruments of rural development that aim at improving quality of life in rural areas, and ultimately in order to ultimately keep the people in those rural areas. And geographical indications is one of those instruments. As it was said many times, they don't have owner, so anybody can use the GI name, which means the profits, this added value that I was mentioning, are distributed democratically, one can say, among the population in the geographical area. You cannot allocate a geographical indication. That means that the jobs are kept in the regions and the people, therefore, are kept in the regions. And that's the ultimate goal. There is a local identity and pride involved, and sometimes it's difficult to say what is more important, if it's the economical value or the pride that is linked to that. In any case, this element is very important element in the system. And geographical indications, they bring tourism to the regions. Again, as with benefits for producers, it doesn't happen automatically. It depends on many other elements: attractiveness of the region itself, the infrastructure, can the tourists actually come to the region, involvement of public authorities in the process, because it's the local authorities that can help with promotion of this geographical indication beyond the region. So it has to be possibly enshrined in the tourism. The geographical indications should be enshrined in the tourism strategy for the region. So there are many aspects that are necessary to promote geographical indications so that they can bring this added value to the region. So they are not a unique solution to all the problems in rural areas, but they certainly can be a very important element. The economic aspect, we see that the price of product with GI is around 2 times higher than comparable product with GIs. And it very much depends on the product. Of course, you see that for wines, this difference is much higher than for agricultural products, probably to put this comparison for champagne versus sparkling wines, it will be different than if you compare some fruits GIs or vegetables GIs with comparable products. Of course, there is still a difference, but the difference is various across the product sectors. Destination of sales. As I was saying, some of the EU GIs are world famous and they are present in third countries. It's 22% of the GIs, and I would not say even that the 22% are world famous, but they are present in third countries. 20% is in the EU market, but big majority is sold and therefore known in the member states only. But it doesn't matter. It doesn't mean that they are less important for the region. I can give you an example from Poland. There is a cheese Oscypek that I'm not sure that is famous abroad and it is sold abroad, but in Poland it's a very famous cheese and it generates a lot of value and a lot of tourism to the region. Protection in the EU and abroad. So as many GIs become well known in the member states, in the EU, and then ultimately abroad, their reputation is often abused, and so the efforts that are put into building the quality, marketing, the reputation, and often those efforts are made through the generations over decades. So those efforts are not benefiting people in the region, but benefiting others. And therefore, we protect geographical indications in the EU, but we also want to protect them abroad. And the same the other way around, that the third countries' geographical indications are protected there and in the EU. So how we do it, there is a direct application path from third countries into the EU, meaning protection under our domestic legislation. There are 348 non-EU GIs that are protected through this path. But majority of foreign GIs are protected in the EU via the bilateral agreements that we are now negotiating also with Kazakhstan, but we have those bilateral agreements with many countries, and we have almost 2,000 foreign GIs that are protected in the EU via bilateral agreements. And then there is also a very important path, the Geneva Act, that was presented by my predecessor, or the previous speaker. And we encourage all our partners to join the Geneva Act and protect their geographical indications via this tool. So that's That's it for my presentation. I hope I was quick. I think I overpassed my time, but I tried to, not to overpass it too much.
Спасибо большое, Малгоrzata.
Thank you so much, Malgorzata. It was very useful information, and I want to know that all the presentations are recorded, and you will have the opportunity to watch, and you will have the access to watch the records. So thank you for your information. Colleagues, I would like to note that in 1:30 p.m. we will have the final meeting, and we are running out of time. 45 minutes are left, so I would like to ask all the speakers to be brief. And the next floor is given to Umedu. Thank you, Umed, for coming to us from Tajikistan. Umed was in the foundation of the work in the changes of the national legislation. He is presenting the international organization Hillsberg International, the project that Julia mentioned in the beginning of her presentation, the project of WIPO, and I hope that in the near future, it will be realized in our countries, and Umed is representing this company that will be implementing it here. Umed, the floor is yours.
Thank you so much. Do you hear me? My name is Sumet Aslanov. I'm representative of the Austrian International Organization, which is Hillsberg International Organization. We work within the last projects throughout the 3 years, so discussing 3 general issues in Central Asia. First of all, covering standards of the goods, so quality, including the standards and exterior condition of the goods. The second point being connected with the issues of safety, food safety, providing the safety of agricultural products. And all participants of the consortium's partners asked us to work more on further promotion of the production, improving their picture image. And if we cover the food safety or safety issues, the marketing is also one of the aspects we should cover. Thank you for the opportunity to take a participation in this forum that is quite relevant for me personally. Unfortunately, from me, no one here in this hall from Tajikistan, but this direction of intellectual property is only at the stage of initial development. Probably you a little bit experience fatigueness after the first 2 presentations, and due to the fact that I'm an active practitioner, I will use the simpler words common for you. For the current stage, one of the representatives of the headquarters of the Intellectual Property Organization is Dilia Sanisheva, one of the figures who came from who originated from Kazakhstan. And you always have an opportunity to address her in order to receive the necessary information at any given point of time. Proceeding to the issue, before the launching, the green one, before the launching, we understood that we need to keep some expertise and experience within the countries. So we worked parallelly within one project which has been funded by the European Union in Tajikistan, Uzbekistan, and Kazakhstan. And we decided to work throughout the active partners who agreed within this topic, especially within the Kazakhstan. We've had a key partner, the most active one, within the work of these 3 issues. We identified that is the Kazakhstan Association of Sugar and the food preceding industry. We discussed the experience of previous projects and found out the common ground in terms of the fact that they haven't achieved the things they wanted because they have no systematic characteristics in their work. That is why we decided to undertake the serious approach for implementation and launch it launched it at the stage of development of the information campaign too. So the GI is the good with already existed reputation. Within the limited geographical area, this product is produced, and it's unique due to its connectivity with the specific location, plus use technology and historical background of the current location. So the climate condition, ground condition, and traditional methods of proceedings. That's all. Talking briefly, but currently on the global market, we do have such a tendency when the consumers pay more attention on the consumption of these projects, and for us it's good to see, because now at the stage of termination of mass consumption of any kind of product, people became prone to choose products in a more wise way. And so if the previously we've seen very few cases of such behavior, now we have more and more. Why is it important for the Central Asian region and neighboring countries? For me personally, geographical indication is the tool of agricultural territorial development. Then it's an instrument of further agricultural development or economic development. The previous speakers mentioned that it postpones the urbanization process, provides new workplaces, and so on. In general, it covers much more things. It promotes the development of tourism, protects the GI or nomination, and then it also increases the interest among tourists and promotes the opening of new workplaces through the development of hotels and transport system. How has it been possible to improve this agenda parallelly in countries? Despite the fact that we use locally for our partners, we also developed the participation with our French partners from Switzerland. We consulted from the WIPO with European Union. So in fact, we spend a lot of time on the consultations and discussion of the documentation in order to understand the practice and how is it implemented within the states who succeeded. We've had a conversation with these consultants. There is no need to have the in-person conversations on the ground, because now we have online tools. So how is it accepted by the businesses? How it is accepted by the governmental bodies? Because GIs or manufacturing of GIs could not be only in capital cities. In most cases, we do refer the rural areas and villages. So we done the comprehensive preparation for the negotiation with the companies in order to provide the necessary level of enlightenment. And the conversation took in general 2.5 hours. So within this meeting, we described the examples, the meaning and definition of the GIs. So we provided such example as champagne, camembert, other type of cheeses. And then after emphasizing some demands, we've continued the work. Of course, it's been not on the national level because there is some limitation on funding, and it's not possible to do this in 2 or 3 years. Then they proceeded to the workshops and trainings. Here you can find the algorithm of events in the region of Central Asia. First of all, we implemented national working group with specialized structures. If it touches upon the agricultural products, we involve the Ministry of Agriculture, Trade, and intergovernmental bodies with participation of associations, businesses, private sector being involved to have a conversation within the roundtables. It doesn't require any funds because that is an ordinary thing organized within intergovernmental body. It's inter-agency level, and one of the sub-agency body covering the protocoling and reporting system is responsible for this event. For instance, in Tajikistan, by the government, it's been noted that expert agency is responsible for these things, and then it distributed the necessary activities and governs all the necessary bodies together in order to have a further discussion, and then they send a protocol and notification on upcoming seminar or session and organize them on the ordinary level. The same is happening in Uzbekistan. And as I think it leads to the association involved attracting the necessary players to move it forward. Then we proceeded to the practice, where we would like to create the register of production, which is potentially could have the impetus of GI. We've been not aware will we protect the nomination or GI itself. In most cases, there's two alike products. The nomination is called by strong GI due to the fact that in this particular limited territory, necessary to have all the operations, the production, packaging, and so on. With GI, we can refer to the one operation, the packaging itself, or separately proceedings, or so on. Just taking the raw materials using traditional methods, for instance. We distinguished all of these characteristics. We do have a natural register, and I would like to recommend to the Republic of Kazakhstan to have an inventarization within the cities and regions in order to identify the first huge lists of the production which can potentially be GI. Not simply dividing into north, west, east, and south, but to take into consideration the small regions or districts, for instance, because they could be unique within very small territory. It could be within the half of the district, or as we call villages, or it could cover one region or two regions. So the GI doesn't have some administrative division. So we refer to the climate, to the nature, and so on. So this kind of things, we moved forward and understood that we need to have the pilot inventarization, after which we classified products, those who are not necessary or do not comply with all the criteria, because we also consider the historical importance, uniqueness, especially with the attachments to the particular location of manufacturing, because we can produce the same product in the different regions. In this particular case, we need to have only one place of production. And after choosing the products, we develop the profile, and the biological product can have a passport too, as well as the human, as the person. So here we classified the type of the product, so the parameters, the characteristics in terms of taste, and so on. Then we created the specification of the products. If you are aware with standards, you know that here we describe technological process of manufacturing, and the specifications are obligatory for use in relation to the GI products. You cannot violate them. That is the list of obligatory rules to use. And they are simple, nothing complicated. They much more easier than standards. For instance, if we produce cheese or meat, for instance, under the GI, we simply described that that's the thing we feed the animals, that things which we allow, this is not, and so on. This type of chemicals we can use, or fertilizers, for instance, or not. The most complex thing is mobilization of the producers. That's stage been done by the local authorities. We need to reach the Economies, the local authorities, authoritative bodies, and provide the enlightenment for it. So the mobilization is the most prolonged stage. Then there's been a necessity to unite all these producers, if we talk about the rural areas especially. However, the private enterprises also get an opportunity to send an application and be registered as producers. However, we promote the idea from the perspective of the agricultural development of the territory to touch upon the collective approach. It also covers the producers, like in Kazakhstan, the Association of Almaty apples producers, and then something like that appeared. And then we piloted the registration on the national level. The previous speakers also described this several times. In order to undergo the international registration, that refers to the WIPO. For instance, we try our best in order to receive the protection of our goods abroad, and especially within the markets which are the members of the classification of the Lisbon system that refers to all countries of EU, covering 27 countries. And if you provide the good work, that will worth it. And in order to position the product as a unique one and introduce not only to the general sale, but to the niche level, the consumers will pay more for that, not a little more, but sometimes we refer to the great difference in price. So here we refer to the speed of implementation and the cost. In general, nothing much left within the presentation. I covered this already. I can draw attention to the challenges and issues we have. As I mentioned, there are complications on creation of the formal group of producers like associations, the lack of knowledge on the GI system on different levels. So there is a difference on national and regional level. So we need to create more informational campaigns on places in order to give an opportunity to people to understand and not to think up the product. Product should have a reputation and the history and have the uniqueness which connects it with the specific place of production. If there is no such a criteria within the inventorization, so it's not applicable. We have such a deep history in the Central Asia, thus so we can identify the variety of such products and then to implement them. The next problem is dissemination of false information. So there is a problem of finding out the true sources of information. Sometimes during the research works, we cannot exceed the set time framework, like within 25 years or 10 years, and so on. For the products, so we tend not to attach to the history. And for the work of the respective specialists, it's been a kind of a complicated task for us. The second point, attachments to the geographical location of the production. Here we need to attract the representatives of scientific fields. And those who have no expertise in these particular issues cannot explain the specific characteristics of the products like taste or color. They cannot attach it to the climate conditions and how they affect the taste of the product, like in terms of the share of the sugar or acids, for instance, and so on. In Kazakhstan, we have more specialists from the scientific fields. In Uzbekistan, the worst situation. In Tajikistan, a little bit better than Uzbekistan, and so on. And so we explained to interagency bodies that there is important for them, first of all. However, the evidence as well, probably partially it's been our fault too. The issue also is connected with infringement of use of the GIs, so there is no protection on regional and national level. Yet, I do not refer to Kazakhstan, I also refer to the Uzbekistan, Tajikistan. And we need to have the specific political will, not only within one product, but within the range of the products. I will not take more time. In general, we've had 4 major projects, hashtag Cohesion Melon, that is tourism melon, Almaty Airport, and Kyrgyz white aspart honey. And in conclusion, I would like to say that we need to understand that there is a request in paying attention to formulate the intangible values. And one of the most famous value, for instance, let's take the France as the common example. It has the great experience, more than 200 years of covering such issues, production of cognac and champagne, that is intangible value and asset of France, which benefits in the form of tangible dividends. Identify the unique product, understand the history of the product, use the legends and myths. I've came through documentation which been described in a historic way, but in most cases it's a kind of the thinking up of myths. We can do everything in the same way. So, and then to attach it to the real historical examples and scientific one. Thank you. Thank you, Ummet. Yes, you put an impetus and motivation to the audience. Colleagues, Ayjan asked the opportunity to be the next because we do have the representatives from science, Tatiana Larina. Tatiana, the floor is yours. She is the dean of the faculty of the jurisprudence of the Moscow Academy and also the member of the Vita Moscow University. Tatiana will cover up the geographical indications in the form of common economic union.
Татьяна, что-то мы вас не слышим.
Tatiana, we cannot hear you. Something is wrong with your mic.
Попробуем подключить вас еще через одного спикера. Сейчас я предоставлю.
Let's join you after one more speakers. Now we will like to give the floor to Ayjan Nauris Galiva. She is the head of the National Expert Group on Geographical Indications. So I'd like to express the words of greetings for the coordination of work in the GIs. Thank you very much. And she will tell us more on the history of creation and about the Almaty Port Apple and the presentation.
Добрый день, коллеги.
Good afternoon, dear colleagues. I would like to thank organizers of this event for invitation and for this specific session for the geographical indications. The topic is very important for us, and I will not take a long time for about the history of creation of Almaty port. I will talk about the work that started in 2019, where the working group was founded when the international experts have come, and we visited all the representative bodies, the Ministry of Trade. We visited the Institute of Intellectual Property and discussed a lot of questions, and we accumulated data of the project that we defined in Kazakhstan. And after long discussions, negotiations, when we chose 4 products initially, Almaty Port, Kızıldağ Rice, Kızıldağ Melon, and the 4th product I can't remember. If Marina will remember. And we chose the Almaty Port finally, and we drove through the whole region of the Almaty region, met all the farmers because they didn't want to show themselves due to some objective reasons, and we gathered them all together and combined in the Association of the Producers of Almaty Port. Here is misleading information. In the May of 2023, the association was registered, and further it was sending application to the registration of governmental agency of Almaty Port, and we had work about defining the taste quality of this products, because we have the port Alexander and a port Pravokrasny. Here we have in the basket the port Alexandrov. In October 2023, we have got the blank of registration by the Association of Almaty Port, and this association includes the farmers that work in the territory of Almaty, the Yenpekshi-Kazatsky region, and Almaty-Talgarsky region. Here is the labeling that will be indicating the Almaty port. The packaging will be marked as this label. The tasks of the association is the promotion of brands both inside the country and abroad, and maximize the maximum prolongation of life of these products. And thanks to the help of the farmers, these products are successfully implemented in the work of the prolongation of the producing these products. For example, producing another projects like for example, in the market we have a lot of examples of Kyrgyz port under the name of Almaty port, and in the association there are 2 committees: the committee of the control of quality that implements the internal control, and the market monitoring. We are working with researchers that work within the Almaty city and take pictures on the basis of which we will indicate if it is a real Almaty Airport or another project that is selling under the name of Almaty Airport. And then we will define some sanctions, control of original Almaty Airport implemented by the association itself, and then it is the inspectors, maybe this independent agency of the certification, and every enterprise should have its passport where the destination, the location should be indicated, and we have, and all the zones that are in the certification have certain passports. Here we have the assessments of the markets, and the association works on the development of the standards of internal control of quality and development of national control of Almaty Airport. We used to have such agency, but it's not in force right now, and we're working on this document. And as we told before, as our legislation has experienced amendments in terms of geographical indicators in the Ministry of Justice and the Institute of Intellectual Property amended and additioned the contracts for the representative body that will adopt a national standard, and maybe there will be some rules of control of products registered by the geographical indicator. And further, we need a body that will implement the control on the market and the products that it is registered in the market, and the body that will give the mark with the protection of geographical indicator. And also we have a committee of promotion of geographical indicators that implement several events on promotion. And the main proposal that we want to offer in the legislation about the objects, the territories on which the objects of geographical indications are registered are protected. And we have registered a problem that one of the producer of this Almaty Airport had an issued we need to identify if this contract was valid or not, that was signed in 2004, and to exclude their lands, because it's not obvious if it is be preserved or not in the future. And today we should have had a regular session, and I will find out it a bit later. And we wanted to have some amendments in the legislation for the registration of geographical indicators. Some groups of producers can apply for this service. So the territory of the producers, once again, it is indicated on the map. On the north side, there is a border of the Zalgars tract, Impikshi Kazakh region, Karatau region, and Alamedeu region in the Almaty city. And the garden that the prosecutor have issued, it is the only garden that is in Almaty and not in the whole region. And I will repeat that the gardens were founded in 50s, 60s, and they experienced some advances. We also have sewers trees, and such trees are old ones. And this year we experienced producement of the new trees, and our colleagues have developed some technologies of preserving, and we can preserve the port till June 1st. This is all. Thank you for your attention. Thank you so much, Jean, and also for the proposals on amendments in our legislation. We will bear it in mind. We have online the representative of Kyrgyz Republic, the governmental agency for intellectual property, Combat, Iman Gazieva. Do we have a possibility to connect with Combat? Can you hear me? Let's turn your presentation on. It will be very interesting to know about the experience of Kyrgyz Republic in this sphere. What successful examples do you have in the GI sector? One moment, please.
Good afternoon, dear colleagues. I would like to express the words of gratitude and for the opportunity to participate in this conference. And I would like to share you the experience of Kyrgyzstan. Just tell us the next slide and we will switch. I will not stop on the definition of the GI. We all know when it's been firstly used. So here we talk about the role of our law in this respect, which been renewed in 2023, and it provided the geographical indications, and we made an amendment into the current law on the statements on geographical indication. Before we've had the implementation of namings, but we do know the difference between nomination and geographical indication, because all the process of manufacturing should be located at the same point, while in the nomination we can refer to the separate procedure. Probably you know that currently we have only 15 entities, and on October 30th of the 2024 we received the first application. That's been a huge work, especially for the association on geographical indications on Astambab walnuts, and so it's worked within the GI projects, and finally they sent an application and we finally moved forward from the start point. Of course, they experienced some difficulties with identification or certification, with receiving of documents and internal documents too. With the charter, for instance, quality control, transportation, but they overcame these obstacles, and currently we do have this kind of a GI. Hopefully, I would like to draw attention to the fact that we have the programs of local development and the national level, which we call the economical projects, One Village, One Product, AVOP, briefly. It's been signed within the order of the President on February 20th of 2023. And within this orders, we developed the project, one village, one product. But this project work starting from 2007 on the territory of the Issyk region. That is the project under the JICA, Japanese agency. And then they launched 7 pilot projects by the local producers in order to express the change that we have opportunity to work locally and proceed something and to have the locally made products. And at the current stage, the project's OVOP launched in several regions. And now we have some alternatives in Kazakhstan and Uzbekistan. We also have a further work, and we established one of the main body this which provided the assistance in the field of the intellectual property. Not so far ago, we signed with the representatives of the university the agreement on cooperation to work locally with the producers. And each representative should send at least 2 applications on GIs. Also, it provides enlightenment, trainings on enlightenment for the local producers, for local authorities, for representatives of the regions. They assist on sharing information that it is possible to develop economy and place, at least by using GI. Because we all know that it's one of the instruments of the development, regional development. That is not only promotion of the project, but also the development of the tourism and so on. Everything been touched upon by the previous speakers, so I think that they clearly understand that it's one of the important tools in regional development, especially due to the fact that all the consumers tend to, as Umit already mentioned, that consumers are interested in consumption of products with the high quality, which pay attention on their quality and reputation. Briefly, that's all I wanted to say. And currently, we do have a work on GIs in each region, in each district. We have specialized objects on one of them. Uzcan rice, Uzcan port apple, is cool apricot, and we have the work in this direction. Last one, Kimenski potato, and the much more. So now, very soon we will have the revision work and then to select separate cases and work within the OVOP, and probably next year we'll have more applications. We do hope for that. Thank you very much, Kambat, for sharing the experience of Kyrgyz Republic. Thank you for that, and hope to have a further work. The next floor is given to Angelina Tarasova. She's always tend to participate in our events. Thanks much for that. And she tries to shed a light on this practice on the perspective of businesses.
Thank you, Marina, for your warm words. For me, my topic is connected. I'm not a representative of the Association on Geographical Indicators. I am the lawyer on the questions of intellectual property rights and protection of these rights. And I would like, in my brief report, we are out of our timeline. I would like to draw your attention and to support the entrepreneurs of small, medium businesses that produce geographical indicators. And we will skip all the geographical peculiarities of these indicators. And I would like to point to the economical developments of the regions of the Kazakhstan and why it is important to develop geographical indicators. First of all, these national brands, we need to develop them because Kazakhstan has a great potential for development of national brands and to go to the international global market to expand our potential. For example, Swiss chocolate or Italian cheese. I think you know that in Italy they have different tourist tours to visit and to try to visit the factory on producing the wines. And why don't we create something like that in Kazakhstan, in our regions? It will be attracting for the entrepreneurs and will develop other directions, the tourism in our country, and attract tourists that will visit not only famous tourist places in Kazakhstan, but also try our national brands. And also it will stimulate the development of the small and medium businesses and also preserve the cultural heritage. And I want to draw your attention on the small and medium businesses. I would like our governmental bodies to pay attention on development of geographical indicators because we need to go ahead, not only registering these GIs. And before this year, we only had 6 GIs, and now we are experiencing new registrations in this field. And I would like to thank a successful work of the Ministry of Justice that they carrying out the control of this not new, but very important and useful direction for our country. The regional support, the centers of supporting the entrepreneurs, and they try to give all the information to the entrepreneurs about the benefits that they will get from the development of national brands. And I have monitored several months ago, there was some information on social media sites that we are developing Talgar Peer, and we are developing a national brand, and it's very useful for our businesses to develop this national brands, and we need to amend some marketing strategies. What will they get from this? And certification for the SMB in order to not having the fees for this registration, or to attract some specialists to attract maybe foreign experts to regions, not to the cities. Not only in Almaty or Astana, but all other cities and other regions of the Kazakhstan, and to talk about the importance of developing this sector. And we need to help these businesses to expand its potential to the global markets. And we have a lot of patent organizations, including the fact that I told Marina before the events, we need to attract castrate for the exporters in this direction. And now we need to be on the part of, we need to support the entrepreneurs and to explain what will they get from this, what benefits what they will get. And I would like to note and that in our shops I'd like to see more national brands, more domestic products that the consumers could digest healthy foods for their healthcare, and we have a big potential for it. And I am supporting and promotion and help such entrepreneurs that are developing our national brands. And here is the conclusion of my report. Thank you, Angelina. The marketing strategy is a very good idea for our future, because everyone has told about the certification, attraction of specialists. The colleagues have had their speeches about these topics, but we need to pay attention to the entrepreneurs because they don't know what they will get from this opportunity, and we need to, the government and other people should be interested in attracting entrepreneurs and to explain them maybe some subsidies, because it's non-tangible assets, maybe direction in the banking sphere, so they could use geographical indicators as for having some loans. I know that in a European patent agency, they promote such initiative in Russia, partially promote such sphere, and I think that for businesses it will be very useful, and they will be very interested in development of national brands. Thank you so much. The next floor I would like to give Gulnara Belgozhina. She's been working more than 17 years in this sphere and represents the National Institute of Intellectual Property that during this year very frequently visits regions and work on that hotspots. And Gulnara, please share your experience.
Thank you for the opportunity to give a report. First of all, I would like to thank all the experts for the unique presentations and for the opportunity to have the mutual dialogue and discussion of the relevant issues in the field of intellectual property. Today, my colleague from WIPO and from European Union already answered to the wide range of relevant issues in the fields of geographical indications. That is why I will not discuss them in details. From the perspective of the organization, which focuses on expertise and registration of geographical indications, I would like to draw attention to the fact that the registration of geographical indication is the most important and the most effective means of protection from the unfair competitors. Within the conditions of market relationship, I would like to remind that apart from the fair competition, we still have unfair competition, where someone violates the general rules of business activities when the unfair competitors tend to dupe the famous product and use it under the geographical indications, which in fact it's not in compliance with the real situation. That is why we didn't need to establish and promote the geographical indications. In the beginning, you need to get the governmental registration in the governmental register of geographical indications. I will not draw attention to each particular slide, so here you can find the samples of the potential GIs. Briefly, I would like to shed a light on the history of Colombian coffee. That is the first sample of successful branding cases of GIs, and in this case is the Association of the Coffee Producers in Colombia. Elaborates the unique certificate of the quality, the sign of quality that has been 100% of coffee. Then they elaborated the strategy of promotion and preservation of the production of the Colombian coffee. And throughout the 50 years, they governed the issues connected to marketing, and now it's one of the most recognizable products in the worldwide market. The Swiss watches are also famous and protected from the perspective of GI. And here I would like to emphasize the little detail that the GI in relation to the Swiss watches, they are protected by their rights if at least 60% of price of the production being done in the Switzerland. And Dolgar Pier, and I would like to draw attention to the Aral soap Jantachne from the camel milk. It's one of the registered as the GI. It's been registered this year. And I would like to note that due to the fact that Aralsk city is in the desert area, the local communities do know on the specific features of the plants which are grown there. And the specific plant been used for the as a mean of medication, and now it's a part of the ingredients for the GI. Here you can find the potential GIs example from the Kurdistan. And this slide is devoted for the producers and business owners. I would like to emphasize that before proceeding to the creation of the GI, as a form of recommendation, I would like to share that before the proceeding to development of the GI, it is essential to do so with the mutual efforts, like in the example of Almaty Airport, paying attention to the promotion of their association, and as well as within the example of Colombian coffee. That is one of the most important steps in terms of promotion of the GIs. The legislative framework and regulatory framework within the national legislative system, sub-laws and so on. The reporting is under the regulation, the Article 27 on the law on trademarks regulates what is subjected to the registration and what is not. Today we have different options on filling the application in the written way or online. More than 95% of the applications on all the objects of the intellectual property are submitted online. The stages of registration are the following ones. First of all, we have an expertise of 3 months, then we make a decision on the registration or denial of the registration, and then there is an opportunity to send an objection, and so on. In Kazakhstan, Kazakhstan is one of the participants of the Geneva Convention, and within this convention, we are obliged to provide the relevant protection from the unfair competitors, and that is the positional system, which plays a great role in this regard. Apart of this, registration of already registered GI could be objected, and here we can refer to the pre-trial resolution and judicial resolution of the dispute of the given geographical indication with the consensus of the expert organization. I would like also mention that as any other fields, the field of intellectual property requires the further development and perfection, and for the current stage we do have relevant issues of enhancing the current legislation in the fields of intellectual property, as well as the regulatory norms of internal and external control. That's been already touched upon by my colleagues, and I would like to emphasize once again that we always recommend to our producers to remember about the importance of creation, promotion, and branding of national products, and unite within the associations. At the same time, the key targets are compliance with international agreements, requirements, implementation of the governmental programs. Here you can find examples of already registered geographical indicators, and this slide has been prepared at the beginning of the week. Within this week, we already registered more, and Irina Nikolaevna mentioned that now we have 38 cases, and I think that is a positive result. As has been mentioned, this year we done huge work on promotion within the field of intellectual property, on promoting the national brands in cooperation with the Ministry of Justice, with Committee of Intellectual Rights, with the local executive bodies. We organized the wide range of webinars and workshops. Here you can find the information sources, and CAS Patent is interagency organization of the Ministry of Justice of the Republic of Kazakhstan, and so we are open for further cooperation. Please join us in our internet resources or social medias. In Instagram, we do have accounts on Instagram and Facebook. Thank you for your attention. That's it.
Спасибо большое всем.
Thank you, everyone. Thank you, distinguished colleagues, for the work you've done, and for the support of the geographical indications. In conclusion, I would like to remind you that we will have the final session where all the moderators will announce the recommendations. I will be brief. I would like to fulfill on amendments in the current legislation. Probably we need to pay attention to the European countries. So when we do register the geographical indication, we need to have the historical characteristics, and if in European countries the minimum requirements 25 years, we need to pay attention to this requirement. Probably when we will try to register the GIs in the European Union, we will face the same requirements. That's in order to exclude any misunderstandings with the colleagues from Europe. We need to include this requirements within the amendments. And for the working groups, I would like to recommend you to consider the opportunity to establish a working group under your committee. With the great pleasure, I am willing to ensure you that I'm ready to work, and also to establish interagency body too, with attraction of Ministry of Agriculture, Ministry of Justice, and so on, and to organize the events, which is already practiced by the Institute of Intellectual Property. From my perspective, I'm willing to provide all the necessary support and to organize it probably in online format with a great pleasure. Thank you, Ayjan, Umet. I would like to join Ayjan's words. I'd like to emphasize that we need to have interagency working group on formulating the beneficial conditions on use of geographical indications in together in practice. So we will not consider the increase of number of the GIs. We will promote the conditions which will positively affect on the process of application, for instance. So that is why we need to attract the necessary interagency bodies, governmental bodies, and also the local representatives too, like representatives of the handmade production and so on. So we need to have the representatives of the private sector to be actively involved in person, and these sessions would be held within 3 hours with maximum amount of time. In general practice, it's quite briefly, and so the session is intensive with reports, because then we talk about the sessions at this level. We do have about the already existing situation with no extra things, with no connection with history of Kazakhstan. Taking into consideration the work of Ayjan, I can say that the work with association is quite effective. Not so far ago, it's been already emphasized. Thank you, everyone. Within the final session, I will announce the outcomes of the session. So we need to have amendments into the system of control and legislative systems, the perspective of international agreements like Lisbon system, establishing inter-agency groups with attraction of representatives of scientific fields and associations, also to identify the perspective GIs, improve the enlightenment work, attracting the qualified specialists, assistance and the for establishment of associations, promotion at the international market level, with attraction of the companies who support the export in Kazakhstan, and also establishment of such an infrastructure as the touristics routes and support of the handmade goods and so on. Thank you, everyone. I'll wait to see you again.
Коллеги.
And colleagues, I'd like to invite you at 5 o'clock to the theater of Konishbayev. That is our new theater. There we will have a award ceremony of the winners of the Shapagat competition with the concert program involving participation of famous artists, and we're happy to see you there.